We've got a great speaker who is just one of my first requests for the guest speaker series here. So each week, if you look at Luma/Insiders, you'll see much more of a planned schedule coming up. And so Gary Kibel is someone who I've known for a long time, I've followed for a long time. If you're anywhere in the ad industry and there's some kind of legal discussion, the odds are pretty good that Davison Gilbert is representing at least one of the parties. I mean, it's a fair enough representation. And their point of view pieces that they share, and I'll include a link to this one in the chat here too, are just fantastic reads. And I mean, they cover a lot of ground, from like a state's privacy law to what's going on in the metaverse to increasingly AI. And I received this one, I wrote Gary right away, and I'm like, Gary, any chance you can come help us make sense of this? Because like every single one of these conversations, there are legal issues that come up, but there aren't usually lawyers in the room, at least not at the outset. So Gary, it's great to have you here, and look forward to getting some of your perspective.
Sure. Thanks very much, David. Happy to be here. And I do recognize a couple of names on the little boxes on Zoom. I thought what I would do is kind of just maybe for 5 minutes, give you my perspective on things that I'm seeing legally in the AI space, and then really open it up for conversation. And, as David said, I'm a lawyer, I've been in the advertising marketing space for quite a long time, over 2 decades. My firm, Davison Gilbert, has been in the advertising and marketing space longer than anybody on this call has been alive. And we're quite involved in lots of different areas. I lead our privacy and ad tech practice, but AI is a big part of what we're seeing these days. So we're seeing a lot of different issues. Maybe first I'll go through a quick legal analysis, then I'll tell you about some lawsuit issues and then some regulatory issues. And then I'll close my lawyer mouth and we can talk for a while. So in terms of the legal issues we're seeing, AI raises a lot of issues. Firstly, when we look at AI, we're always looking at the training data, the input data, and the output data. And I'll talk about those in just a minute. So in terms of legal issues, there are copyright issues, trademark, right of publicity issues, contractual issues, and privacy issues. So on the copyright issue, as you may know, if someone makes a work of authorship, you write a book, you write a poem, you take a photograph, you paint a picture, you own the copyright in that. So the issues come up with generative AI. Who owns the output of this AI that's been created? And if you dig into the T's and C's of OpenAI and other platforms, they're a little cagey. They say, as between us, you own the output. But as between you and the rest of the world, good luck. We have no idea. And the US Copyright Office actually put out a statement about this as well. I think it was about a few months ago, where they basically said that a computer cannot own a copyright, and a computer cannot create copyrighted material. Copyright belongs to an original work of authorship made by a human. And a little fun war story. This is actually not a new concept. If you want to read a good read sometime, Google monkey selfie, and you're going to read some interesting articles about a story from 10 years ago, or more than 10 years ago, of a very famous nature photographer who was in the jungle in Africa, and a monkey actually picked up his camera and took a selfie of himself. And I think the monkey's name was Naruto. And it was just the funniest picture you've ever seen. And I'm sure somebody's looking at it right now. And then everybody started posting it online, and the photographer said, hey, that's my photo. I own the copyright in that photo. And he tried to register the copyright, and the Copyright Office said, well, wait a minute. You didn't take the photo. The monkey took the photo. So you don't own the copyright. So that same concept comes up with generative AI. If OpenAI spits out something fantastic, you may not own the copyright in that. So that feeds into some other issues I'm talking about. Same thing with trademarks and things like that. Say you're an ad agency and you have a contract with a client, and the contract says everything I create for you will be original and you will own it. But now you use generative AI to create some content. Well, you may not be complying with your contract now, because it's certainly not original what you've created, because you don't know what OpenAI did with it, and the client may not own it. So we've actually seen ad agencies come up with contract addenda when they're going to use generative AI in connection with a client campaign, so that everyone's on the same page. To say, hey, look, we don't know if you own it. Between us, fine, you can own it. But we don't know as between you and the rest of the world if you own it. And also, I don't want to be liable if there's any infringement. So same issues come up with trademark, right of publicity, because you've seen fake, politicians, fake actors coming up. And there's been some lawsuits. One of my favorite comedians, Sarah Silverman, she is suing OpenAI. So I'm just by default, I'm on her side, because she's awesome. But her claim is that, OpenAI is scraping the web everywhere for the training data and taking people's copyrighted content. In a different lawsuit, a judge said, well, what content of yours did they take? And the plaintiff was like, well, I don't know, but they have to be taking something. Getting Images has sued some generative AI platforms because they assume that they're scraping photos out there on the internet that Getty owns the rights to. So the biggest takeaway that I give to clients when dealing with generative AI and the marketing concept is that you have no idea what the training data is. You have no idea what they're searching, but you do have control over the inputs and the outputs. For your input, don't ask it to create something that's likely going to infringe. Don't say, give me a song in the style of Taylor Swift, because you're going to end up with something infringing. If you say, give me a happy song somebody would sing on a Saturday, all right, you might get something generic. And then look at the output, like you would with any creative, and say, does this look similar to something I've seen before? If so, maybe I should stay away from it. I'm going way over my 5 minutes, David, but two other things I want to throw out there.
Please, yeah, this is all great.
Talk. So what are lawmakers and regulators doing about this? In the US, we don't have an AI law, although with all the craziness going on with privacy laws, it's interesting that regulators are starting to shift their focus to AI because they feel that the boat has already sailed on privacy. The Federal Trade Commission, the FTC, has put out statements about AI, and the FTC can regulate deception and unfairness in advertising. And they're concerned about deception in two ways with AI. They're worried that people are using AI and they're not disclosing to a consumer that this is AI generated and it may not be real. And they're concerned about the reverse, that people are saying, hey, our product is, created with AI, and it's not. And you're just saying that to get buzz. So they're worried about that. And, and then, look at the SAG and AFTRA strike going on. The actors are terrified about being replaced by AI. And in Europe, there's been some regulatory action as well. Italy actually banned ChatGPT for a period of time over privacy concerns, because they figured that the platform is processing personal information of EU residents without their consent. But then OpenAI agreed to make some changes and the ban was lifted. But with that, I've thrown a ton up against the wall to see what sticks. And I saw some heads bobbing here and there. So I'm sure there's some questions, some comments, and I'll kick it back to you, David.
Yeah, well, this is why it's like I feel like we could have you here every week and only scratch the surface. I mean, just even on like the agency contract side, are you seeing like now like this just happen more as like a preventative, like just like put this into an initial contract when you're signing a client or renewing a deal, just like in case they use generative AI for a certain piece of work? Is like, are those sort of like what if scenarios starting to be worked in?
Yeah, and I was talking about from the agency's perspective, but that's a good point, David, because I actually saw that a week or two ago, a clause put into an agency client contract from, I would say they're a Fortune 10 marketer, really major, but it was a short paragraph and basically said, you're not going to use generative AI for anything without our approval.
Wow.
And I think they were just kicking the can down the road because they were like, we don't know how to address this, but if you agency are going to use, generative AI, we need to stop the presses and have a conversation.
And I mean, just like, I mean, there's got to be other parallels, and it's a little bit beyond me right now to even think what the closest one is. But like essentially, how does that even get policed? Yeah. I'm a creative, or I'm even doing like data analysis or coming in at certain parts of this. I'm working remotely. I'm on my personal computer that agencies, I'm not on their VPN or stuff, and I'm getting, say, a lot of inspiration. And I share that, like, I don't necessarily tell my boss what I'm doing here. And my boss, oh, this is great, we're ready to pass this on to the client. Like, they don't know what's been assisted, right? Like,
yeah, and you threw out a really important word there, inspiration. And companies have been coming up with AI policies internally. Actually, law firms have been coming up with AI policies too. Because there's a very famous case, again, if you want to Google and have some fun, about a lawyer in New York who used AI to develop a brief that he submitted to the court, and it had fake cases in there. And I mean, this guy had a disciplinary hearing. It was a really big issue. But there's a difference between inspiration and the actual deliverable. So if you were, as a creative person, using AI to get some ideas, that might be okay. But the actual deliverable, the actual thing that you give to the client would have to be real. And the way that it could blow up with a client is, say you use AI to create a deliverable, you give it to the client, you didn't tell them about it, it may violate your agency client contract, and then someone sues over that creative because they say, hey, that's similar to mine, it stole my idea. The client gets sued, which is a nightmare. Then the client finds out you used AI without telling them, so you probably breached the contract. And then a third thing, they're like, well, wait a minute, we pay you like this huge amount of money and you made this creative in 15 seconds using AI. It's like, I want you to indemnify me for the lawsuit. I want all my money back that I paid for you for all the supposed creative work you were doing, and you're fired. So, it could be a bad thing if you don't have this conversation. And I tell clients, like, look, if you're going to use AI, just be transparent with the other party, talk with them, see if you need to deal with your contract, but make sure that you're both come to the table with this understanding about the risks.
now, and one more question, then I know there's some others that are starting to pop up, and so we'll take this to the floor here. But there's more and more use cases of AI where, say, Coca-Cola, I import my whole either whether I'm on the brand side or an agency working with them, I import my whole brand library, right, into this private instance of an AI tool, so I can go and like mine this for more things, and like now, or I might write something and say, now compare how this holds up with Coca-Cola's brand guidelines, right? Like, so I'm creating my own like private models here that are trained. Like, are you seeing any contracts and discussions around this where it's like proactively allowing some sanctioned use cases like that? Like, is that starting to come up too?
Yeah, we're starting to see more use of AI in closed environments. So that, remember, I talked about the training data, input data, output data. If you can be comfortable that the training data that the AI is using to train itself is all safe, then the output is very likely going to be safe. And I'll give you two examples. Adobe has a product called a Firefly, and they say that the training data is all things that they have vetted. And I think if you pay them a higher licensing fee, they're actually willing to even indemnify you for any infringement claims. So I've seen some of the creative space use Adobe Firefly. And in the legal world, LexisNexis, which lawyers use all the time, they're coming out with an AI product, but their AI product, again, the training data is only going to be data within the LexisNexis world. So it's not going to be scouring the internet and maybe give you fake cases like that other lawyer had. It's going to be only things within their world. So I think that idea of using AI within a closed universe is going to grow and grow and be more popular.
Well, this is great, and now love the questions are pouring in. I'm not surprised. This would be a very hot one. Let's just so I can keep track. We'll start going in order, and then Lynn, I'll make sure to include you as well. But and Paul, you had actually reached out to me first. The ethical responsibility was the one you wanted to cover. Feel free to chime in here.
Yeah, my dog has finally stopped barking, so I thought I would. So I published a newsletter about the AI ethics and its intersection with marketing. And I want to know, and maybe this is too general a question, but I'll throw it out there anyway. What side, ethically speaking, what responsibility falls on the side of the AI developers? What responsibility falls on the side of the marketers, or maybe in your case, an agency, for example?
Right. So, like, you're talking about the platform developers of AI?
Yes, like the OpenAI and such.
So, I mean, they've got two issues going on. They have their terms and conditions between you as the user and them as the platform, and their terms kind of make sense. They like, as I said, they said between us, you own the content, we don't own it, but we don't know if it's original because we use training data. You like the same output as somebody else. So their terms and conditions between the two of you kind of make sense. But between the rest of the world, they're scraping the internet. And the question is, are they, going back to what David said, is the AI platform using the rest of the internet as inspiration, or is it really copying things from the rest of the internet? And that's what the lawsuits are claiming. The lawsuits are claiming you must be copying stuff because there's no way you're coming up with all this original stuff without copying something. But, the way the world works, I mean, copyright is not like a patent where, if you have a patent, it doesn't matter if somebody else heard of your patent, did not hear of your patent. If they do the same thing, infringement, story over. Copyright, it's like, I can paint a picture of a beautiful sunset, and Paul, you can paint a picture of a beautiful sunset. As long as you don't copy mine, we're okay. And you can even be inspired by it. You could see, wow, Gary's painting is awesome. I'm going to go make a painting too. That's also fine, as long as it's not a copy. And so we don't know what's under the kimono here, with the platforms when they spit out the output, is the training based on, 1,000, 10,000 different, elements of training data, or is it based on two? And that's what we don't know. And that's what the lawsuits are trying to figure out.
So,
Okay.
Hey, David, I have just to jump in here. How is this any different, right? From, let's say, you're a designer, you're a copywriter, right? Where you're just relying on the eons of experience that you've had, over the years, where you are seeing imagery, working on different stuff, and, drawing from like your memory bank of things that you may have done in the past, or you've seen in the past, and producing content any different from AI doing the same thing, right? You're essentially relying, you can't trace it back to any one thing that may have inspired whatever you're doing. But yet, it seems like there's still some legal claims that if using AI, you're infringing on copyright, but forgetting about the eons and reams of information that you've read over your lifetime that helps you develop a concept.
Yeah, I think it gets to the point of knowledge. So if you're making something creative and you're just using your brain, you don't remember where something came from. It's probably, a collection of experiences, and you're probably going to end up with an output, hopefully, that will not be a direct copy of something. And say you did a Google search for inspiration, you see the sources, you know where things are coming from. So hopefully you're careful and say, oh, that came from whatever, I'm not going to copy that. With AI, you just don't know. You don't know where it's coming from. And you get this output, you give it to the client, they post it online. It could be a complete original creation by the computer, or it could be, hopefully not, but it could be word for word copy. You just don't know. And that's the challenge without having that knowledge. And that's why these other platforms that have a closed universe are saying, we know where the data is coming from and we're comfortable where it's coming from. with completely open, AI tools, you just have no idea.
Well, I mean, one question, Thomas Bloom brought this up, and Gary addressed a little bit with Adobe, but now it's like, the difference between an AI tool and not, like, you use Google, you use Bing, you use Dropbox, you use Airtable, like whatever your tech stack is, like, AI is now built into it, especially if it's an enterprise grade tech product. Like, AI is doing something in there right now, right? Like, is there even any way to distinguish like what it means to use AI or not? Like, it's like, what's digital media separate from media, right? Like every form of media is trafficked digitally now.
Right. I mean, yeah, like if I were, say, writing a policy for an agency about AI,
Mhm.
I would say you can use AI, again, we'll harp on the same word, for inspiration, for learning, for, sparking, ideas, but you can't use the output of AI as a client deliverable in whole or in part without, talking to the client, making sure we're okay with our contract. So, and there's been policies that have been put in place for law firms as well to say, hey, you could use AI as an inspiration, but then go do the legal research. Don't rely on what was spit out by the AI. That's not the end of the process. So I guess if I were dealing with an agency, I'd say, yeah, it's a great tool for, sparking creativity, but it's a completely different story when you use it as a deliverable.
So I think this is a good segue to Paul Stadnick's question here. Paul, if you want to chime in.
Oh, I had a few, but yeah, sure.
That's true.
Well, so it was great that you start off with the monkey selfie, and you mentioned at one point that a computer, according to the Library of Congress or Copyright Office, the computer can't own a copyright. But at what point does the ownership shift to a human being? Is that definable?
Yeah, I mean, it almost sounds like you read one of the publications from the Copyright Office, because I think in one of their latest publications, they did talk about if you're going to try to register a copyright for something that's been created in part by AI, you need to identify the part that's AI and then identify the part that's human creative, because you will own the copyright in the human created portion, but not the AI portion. And so they're trying to figure their way through this, because there's going to be a lot of litigation and they don't have all the answers yet. But they realize there's going to be a blurring of the lines between what the computer created and what the human created.
But what the human created and copyright law are intrinsically tied, right? Because it's a matter of economics, right? And so the copyright exists to protect the economics of the human that owns the copyright. In a world where it's impossible to distinguish between, and I'm making this assumption that it's impossible because currently it's not possible. It may be in the future, but at this current moment, you can't distinguish between human versus computer or anything in between. At a point in the future, if all content has some type of AI gen in it, do you need to re-review what copyright essentially means, or the nature of copyright law in general, and whether or not its purpose in protecting, somewhat of an antiquated economic setup that benefits humans when computers are really running the show? Does it, like the agency that's saying, hey, I'm not going to pay you, you use Gen AI and you spent 5 minutes and I paid you for 50 hours. Well, that's buyer beware, right? I mean, if somebody's using Microsoft Word instead of clacking away at a Smith Corona, is it really up to the author or the typer to advise and consent as to what's the level of effort it's taking to generate this content, or are you paying for the content? So anyhow, I'm going to stop and let you talk.
Yeah, I mean, I think they're all struggling to find out, at least from the copyright perspective, what do you own, what do you not own? And you're right, copyright is designed to protect the creator. Copyright law is designed to protect the creator, to give them limited exclusivity in their creation so that it encourages others to be creative, which is to be distinguished from trademark law, which is different. Trademark law is to protect the public, so that the public is not confused as to the source of goods or services. So how do you continue to protect the authors and incentivize them to create more content when there's things that are blurred together? I think there's going to be some lawsuits. I think what's going to happen is people are going to register copyrights, and the way that copyright registration happens, it's almost like a rubber stamp. You send it into the US Copyright Office. They basically look at it and say, it seems to be what you say it is, so here, you have a copyright. But then there's litigation, which can really dig into whether or not you really own it or not. So I think there's going to be litigation, and I'm looking forward to that, because that'll give us clarity, about what people can own. Because yeah, I don't think it's black and white here what people own. And then going to back to your agency and the client thing, I mean, that's more of a contractual issue. Did you defraud the client? Because did you submit a bill to them that says, we spent 50 hours and we really spent 5 minutes? Did the contract say we're going to devote a team of X number of people to your account and you used AI? So it's more of a contractual breach fraud issue between those two parties.
Hey, do you mind if I jump in? Hey, Gary, Brooks Marsh. It's been a
Brooks.
while since we connected.
Yeah,
Hope
nice
you're
to
doing
talk.
well. I just wanted to jump in on the computer generated versus human generated and where the line goes. So there was a piece of art that won a competition, and the artist used AI to generate the piece of work. And it was really only this particular artist that could have created the prompts and refined the prompt after prompt after prompt that ultimately created this piece of art, that it would be very hard to unwind the human portion and the computer portion. And the Copyright Office still ruled that it was not copyrightable. So I do think eventually the rules will need to be looked at, but as of now, they really are holding firm to copyright has to be is only granted to a human. And I think in some ways they're also trying to protect artists, but it will eventually have to be relooked at, because it is so intertwined. And a lot of the professionals think that the Copyright Office got it wrong, for sure.
Yeah, that's great. That's actually really interesting. I didn't know about that one. I'm going to look into that one, because yeah, my gut would be like, if the artist had so many unique protectable inputs, then there's got to be some element of the output that they own. But yeah, I mean, we're all trying to protect the humans from us being, wiped out by Skynet, and like, I mean, that's what the SAG and AFTRA thing is all about, because they realize, wait a minute, if you go and use a computer to create an actor or actress, that's not hiring non-union talent, which, a SAG signatory hiring non-union talent, there's rules about that, but there's no rules about a SAG signatory using a computer to create a character or a person, or a voice or something like that. So yeah, it's creating so many great new issues. That's why when I give talks or give presentations on this, I start off by saying, I'm going to give you lots of questions and a few answers, because we don't have them all yet.
As in Brooke, I think I put the right one in the chat, but if it's a different one, feel free. Elena, you want to chime in?
Yeah, I mean, to me, this is like, there's so many different rabbit holes. I love this conversation. There's so many different rabbit holes you can go down to. When I think of this from a media planning and buying perspective. And to me, I always think of AI as like, what can it do to help us and help us focus on the thinking and actually doing our jobs? And I think the artist example is a great case. You have this information that only you, knowing your client, can input into a media plan or a media buy. And an AI tool, I mean, to me at this point, it can give you, okay, I'm using the best practices across media and who your target is, to say, okay, here might be the base media plan. But what it's missing for me is that kind of, I guess, IP knowledge of where you want that media plan to go. And to me, that can apply to art or to a story. And so you might say, okay, as an artist or a writer, you might say, okay, I want this, or a creative director, I know the baseline, but I just want a baseline to build on. And it kind of goes back to that inspiration versus using it, and whether that's done by AI or just your life experience. It just, to me, applies to so many different things, whether it's, you know, copyright, or unique approaches to media for clients. And then to me, the negative of it could be, you know, say somebody says, okay, you know what, I want to make sure my copyrights aren't taken, so we're using AI to come and suss that out. How do we balance that to say, okay, I'm just using this story to be inspired, but I'm worried about being sued, so it creates kind of like a writer's block or artist's block. And does that negate or shrink our world of creativity?
Yeah, I mean, I think it's taking problems that have existed, you know, concerns that have existed in the advertising world for decades, and just now they're heightened with the use of AI. I mean, going back decades, at Davidson Gilbert, we'd get, you know, scripts and storyboards and rough cuts from agencies to do, like, you know, copy clearance. And sometimes you'd look at it and then you'd speak to the agency and say, what was your inspiration for this? And you'd get a cagey answer and couldn't quite figure it out. And then you shoot it around to some colleagues and someone says, you know, that kind of reminds me of this particular movie. And then we start to dig down and go back to the creatives, and they're like, oh yeah, John Doe, who worked on this, you know, he loves that movie. So it's like, all right, now we got a problem. So, but it was kind of harder to peel that onion and find the problem. Whereas here with AI, you know, in a few seconds, you might create the problem. But again, you're not going to know unless, again, you socialize it amongst some colleagues and say, hey, does this look cool to you? You know, but then it goes out to the marketplace and someone jumps up and says, oh my God, that's my painting, that's my poem. And that's why it's a horrible risk, because, and that's why I've worked on addenda between agencies and like major advertisers. And we basically said, look, we're going to use AI to create some creative for you, but you brand agree that we agency are not liable if this thing infringes, because we all know there's no way to control this. And so if you want us to be the cool hip agency for you and use AI and it'll save you money, and then you'll go out to the marketplace and say, we're such an awesome brand using AI, you've got to agree that we agency are not responsible if something goes wrong.
Yeah, and there are other questions coming in about transparency, and one it came from Paul Cheney, was on the transparency of, like, from creators, right? Like, you know, and I like that parallel, Paul, of like the sponsored content, and kind of came to all these rules around that. How much do creators need to do that right now? And is do their audiences need it? Do they need to protect themselves legally? Like,
right.
Yeah. Where does that fit in?
I think so that was one of the things when the FTC was talking about deception both ways. You know, when you're using AI, not telling people, and when you say you're using AI, but you're not. They were concerned about both. And I mean, but it's another deception claim. It's just like having a car commercial says the car goes 0 to 60 in 4 seconds, but it really goes in 8 seconds. You know, that's deception. I mean, I literally had a client working on an AI. It was really wacky. They wanted to put out a campaign saying this was created using AI, but they didn't like the output from the AI, so they made it themselves. But they still want to say this was made by AI because they thought it was so cool. And then, you know, I put my lawyer hat on. I'm like, that's deception. But then they're like, they were actually really smart. They're like, well, this is not going to influence someone's purchasing activity. It's just cool. And I'm like, all right, if we go to the courts and we have a lawsuit with the FTC, you might win, but you're going to spend $1 million literally on fighting the government. So you don't want to do that. But I mean, because that's the issue with deception. With deception does it deceive a consumer in a material manner that's going to affect their purchasing decision or their activity? And it's possible that, you know, the AI deception is not going to deceive them, but regulators are just very concerned about being very transparent.
Mhm. Yeah, yeah, and I feel like there's still some confusion that comes up in terms of like what's a sponsored post or not, like even just like when you're searching for something, or just in like a lot like all this like advertorial realm. So this is
Yeah, I mean, and that's how, you know, in search engine marketing that, you know, posts became labeled as sponsored, is because the FTC said, we think that boosting up search results based on how much money someone pays to the top of the page is deceptive, because a consumer is going to think when they put in the word shoes in Google and one company comes up first, they're going to think that that's the most popular one or it gets the most hits, and you need to have a disclosure so that someone's not deceived. It was all about deception.
and then, you know, Laura Fredericks also, she chimed in with like just wondering on the developer side, like how much, I mean, and Laura, feel free to, I see you turn on your camera, so I'll let you share.
Sure, yeah. So I'm coming at it from, I guess, kind of a niche angle, so I don't want to make it about me, but we're developing a tool for inline editing to make sure that marketing communications are compliant, and we're doing that with AI. But we need to make sure that people trust our tool and are willing to use our tool. And I'm wondering how far transparency actually goes in helping people to trust a tool like that. And, you know, if they can see how the AI made its decision or have some kind of trail that they can follow and breadcrumbs that they follow, I wonder, you know, if that helps people or whether it's still too murky for people at this stage.
Yeah, that's an interesting twist on transparency, because the transparency will make people trust your platform more. But if you give too much transparency, you're giving away your secret sauce. So
Sure.
yeah, so you don't want to do that. I mean, I don't know, there may be some way that, you know, like make sort of a demo and explain to people, explain to people how the output is going to be original, because, you know, I'm just making this up. You know, every output from our service is based on 10,000, you know, pieces of training data. I don't know. To make someone comfortable that, oh, okay, this output is not going to be an identical copy of somebody else's work.
Mm-hmm.
And yeah, literally just thinking about that off the top of my head. It's like, yeah, if I was using a platform for some kind of creative output or deliverable, and the platform said to me, every piece of output is based on 10,000 pieces of training data, that might make me really comfortable that like chances of me infringing something are like next to nil if they're using that much data as a training data.
Mm-hmm. Yeah, just interested from the platform side. Thank you.
Yeah. And then, of course, the platform, you want to have a good contract with your platform user to say, hey, platform user, best of luck. You know, we're going to spit out the output and then good luck to you.
But yeah, especially for compliance, we're not getting involved in their decisions ultimately.
Exactly.
Thank you.
And now it's like when you think of like generative issues that come up from something that might be trained on like a more a closed set of AI data, like, you know, I'm just thinking now, and it's like you have my head spinning here, Gary, but like with the AI chat from New York City, right? So now like Eric Adams is very excited about this, making like New York all AI powered. But like, what if it spits out some misinformation and that either causes like actual harm or just say perceived harm, right? Like it just inconveniences someone and they don't like that. Now, and the chatbot does, it sort of reminds me of using Perplexity AI, like it's really good at showing its sources. It won't just opine on like what the best bagels are in the city, unfortunately. But it seems like there's a really big risk in getting that wrong and then someone taking some action that is like they don't file for a license because AI told them their business doesn't require them to do so, and then they get fined by the city, right? Like you just imagine a lot of really bad scenarios coming from this that like could still happen if they called, you know, the city hotline 311 and someone gave them some bad advice, but it like, you know, it just, there's that like scarier, like it feels worse if it's AI, you know, generating that.
Yeah, I mean, I guess it depends on what your duty is to the user. You know, and as a government agency, you may be fairly well protected. Although, and I forget the terms from law school, like ministerial or executory functions. It's like the old example was you can't sue the town for putting up a traffic light, but you can sue the town if the traffic light was malfunctioning. Yeah, if it gives you wrong information, people rely upon it, and there's actual harm, then someone could have a claim. You know, hey, here's an example, which I hope never happens. You know, your primary care physician decides to have an AI tool so that you don't call him or her, you know, and ask for medical advice, and then the tool spits out the wrong thing, tells you to take, you know, medicine A instead of medicine B. Well, I think you have a great medical malpractice claim against the doctor for using that. Yeah, it all depends upon what your duty is to the user, and does it really impact or harm them?
Yeah, and you could still see that those versions of that happening by like, you know, chatting with the brand and saying like, oh, you know, like are there trans fats in there? You know, does this like
Yeah, it'll be like if you were chatting like, you know, McDonald's uses it, and you chat and you say, you know, what does, you know, Ronald McDonald do in his free time, and it gives you some, you know, funny pithy answer, you know, versus, you know, what's the calorie content in a Big Mac? And then,
yeah.
you know, I mean, and that could affect you and, you know, in your health.
And meanwhile, Thomas Blumer brought up a good point in the chat, and I'm surprised we didn't get deeper into this yet. Watermarks, because like for a while that seemed to be the big buzzword, that watermarks would be the solution for everything. I don't know, but like how feasible is that? Like how bullish or bearish are you on this is a solution for anything?
I mean, maybe it's part of the solution. It's part of the mix. I wouldn't even say it's a huge part, but it's almost like we talked about, you know, search engine marketing, labeling something as sponsored. You've now told the consumer, you know, think about influencer marketing, and you got to have, you know, hashtag sponsored, you know, by whatever brand. It's all about telling the consumer what's going on, so then the consumer can independently make their own decision about whether or not to rely upon that. So if there was, you know, going to your, you know, New York City, you know, AI tool, you know, say it was embedded in something else, you didn't really know it was the AI tool, but the output, you know, has a watermark that says this was generated using AI. It's like, all right, then as a user, I can sit there and say, all right, I should be a little skeptical about whether or not this is accurate because it wasn't a human telling me. You know, there's a chatbot law in California that if you have a chatbot, you're supposed to disclose to the consumer that it's a computer and not a human. And that's it. That's really it. And the whole point is, again, being transparent with the individual so that they can then be skeptical about what they're reading or hearing.
This is great. Well, you know, with the last 10 minutes, and there are a bunch of things in chat coming up. Anyone want to chime in with anything that we didn't cover yet with Gary? So feel free to just jump in.
I'd love to follow up on the question I left in the chat about the new bill that's being offered up on a bipartisan level, where you cannot impersonate anybody that you aren't, the same way that like in real life you can't say you're a cop if you're not, because there's real harm that can be done there. But in a virtual space, there's real harm if you impersonate. Just the law you said about am I AI or not, am I me or not, and how I guess applicable it would be. Not necessarily, you know, today, although everything that's coming in deepfake wise, I think is really important. But a few years down the road, when this is way more prolific, what we're going to need if this isn't it.
Yeah, I mean, I suspect you're probably going to get some sort of AI law on the state level. before the federal level. I mean, look, Congress can't even agree on ordering lunch, at this point. So, agreeing on a law on a very complex new technology, I think is going to be challenging. They're all talking about it. And the FTC is up on the hill saying, you guys need to do something, empower us, to regulate this, but I just don't see them doing it. So, but I could see, like California or something like that coming out with an AI law, and then, kind of becomes a de facto national standard.
Right, that's Jamie. Who else has something we haven't gotten to yet?
Gary, I just want to, this is very specific, but I just want to make sure that what we're doing is, get your opinion on it. And it's pretty simple. If I write 100 words of copy for an ad and I put it into OpenAI and I say, improve this copy, and it shoots me back a bunch of suggestions, and I look over and I go, oh, those 2 or 3 sentences are better than mine. And I cut and paste them into my copy. So it's 3 sentences out of many. Do I have to disclose that as you would today, would you think?
Yeah, so I mean, and there is a publication that that the Copyright Office put out. I think it was maybe during the summer or something like that, basically saying that, if you want to register a copy, you need a copyright, you need to identify which portion of it is from AI, if any AI was used. So yeah, in your example, it's like, all right, so 4 paragraphs came from me, 1 paragraph came from AI. I need to disclose that because I may not own that portion.
What if I just change a word or two? Like I don't even take their sentences. I know I'm splitting hairs, but I just come, I take like, I go, oh, that word is so much better than the word I chose, and I pull that one over. It's still my sentence, but 1 word has changed. Still have to disclose it, you think?
Yeah, I'm not sure. It's such a gray area. I mean, my personal view is that that would be more just inspiration. It's no different than, David, gave you an idea for a different word to put in there, and then it's still your creation. But yeah, it'll be interesting what the Copyright Office would say about that. I would think it would be so de minimis that it's not going to change the nature of the work that you're creating. But others could differ. As Brooke said with her example of that one case with the artist, that, people thought that the decision of the Copyright Office was wrong because there was enough creative work going into the artwork, but the Copyright Office, they're nervous. They're nervous about opening up the having a dam break about all these like AI created pieces coming into them for copyright registration.
That brings me back to my original question, because where we really draw the line, because you may not use an AI, but then Grammarly helps you, like, well, is now Grammarly an AI or not? Or Word has, it proposes how to write better. It's like, well, that was not really me either, and the system gets smarter and smarter, so it gets really more and more tricky, so.
Yeah. It's really hard, and the U.S. Copyright Office right now has, they're a little bit different than other agencies, but they're trying to come up with some AI policy, and when government agencies do that, they put out a notice to the public that you can submit comments. So they're actually in a comment period right now, I think through the end of November, and then after that, they are supposedly going to go behind closed doors and come out with some policy statement on this. You never know if that's going to take them, 2 months, 2 years, 2 decades. I mean, because literally, I'm saying that almost as a joke, but there are some agencies where like it just goes into a black hole and you never hear anything. I mean, we're literally still waiting for guidelines from the Department of Justice on how the Americans with Disabilities Act applies to websites. We've been waiting for guidance for over a decade. It's just not coming. So, but they're in this comment period right now. So the Copyright Office is basically telling the world that we're going to come out with some guidance and we want your help because we don't know what it should say.
Yeah.
Is the prompt at all in consideration for copyright? Since there would be no generative AI without a prompt?
Meaning that the prompt has protectable value in itself?
It's an essential precursor to any generative AI, right?
True. But you know, to take a contrary argument, it would be the same as me saying, Paul, go take a picture of the mountains. And you do. I don't own the copyright in that. I told you to go take the picture and you didn't have that. I'm like, wow, I didn't know I should take a picture of the mountains. That'd be a great idea. You know, but I told you to do it. I don't own the copyright in that.
All right. Any last questions for Gary?
One more really quickly. We've been talking a lot about generative AI, but in terms of predictive AI, like computer vision and natural language processing, that's been around not longer, but it's been more available to the public. You can use AWS to do that. And there really haven't seemed to be, but it's using training data and it's using a lot of it. And people are using those outputs to try to help predict what videos are going to work, or, you know, something like that. What, you know, some sort of language that could work better. Why do you think that hasn't gotten the scrutiny that Gen AI has, or has it, and or will it?
Yeah, that's really interesting. Possibly because the output is not something that's protectable. You know, copyright doesn't protect everything. It protects original works of authorship. So if I wrote a sentence that says, my name is Gary Kibel and I'm a lawyer, that's not protectable, even though I wrote it, because it's a fact. You know, there's nothing creative. But if I wrote something very creative and there's a lot of style and stuff like that, then it could be something that's protectable. So maybe with that, you know, those other uses you were talking about, Paul, it's just that the output is not something that is protectable to begin with. So no one's going to argue over it.
Thanks, Paul. Well, this is great. I think we're hitting a good stopping point here, Gary. There's obviously a lot to cover, so you know, I recommend others check it out. The Davis and Gilbert alerts, they're so helpful, and I recommend others consult actual lawyers instead of just asking ChatGPT to write legal policies for them. So yeah, well, I would definitely love to have you back at some point. I mean, and everyone, like, this is probably like the greatest share of attendees all asking questions and participating that I've seen on like any kind of virtual event in a long time. So appreciate all of you chiming in. And yeah, we're going to be doing these kinds of things a lot more. We've got a really fun one next week from a marketer turned chocolatier, and a lot of great topics coming up. So just psyched to get to learn from everyone in this room, and have a great rest of your day.